Howdy. Let's go on and talk about legal issues and ethics. This is a act that was first passed after the 9/11 attacks. It's hard to believe we're coming up on the 17th anniversary of that. So many of you, in my last class, when I asked, they were kindergarten or something. But it, as he says, changed the checks of laws and balances and laws related to privacy. Now, listen to what I'm going to say. The tipping point in security, I believe, is privacy. I would ask you, what is privacy? I don't know. I don't know what privacy is. I know that the definition is that there is no statutory definition. Not even the 1974 Privacy Act defines privacy. Our notions of privacy come from court decisions, Roe v. Wade being one of them. Many people think Roe v. Wade is about legalizing abortion. It is not. The legal analysis was about privacy, and the consequence was about legalizing abortion. There were actually later court cases that set restrictions, but we always go back to Roe v. Wade. Privacy notions in this country, we don't have a statutory general definition. Yeah, we can talk about privacy data with health records under HIPAA, but I'm talking about privacy. Privacy in itself goes back to a law journal article written in the 1890s by future Supreme Court Justice Louis Brandeis and Samuel Warren, and they define privacy like this: the right to be let alone. Hey, leave me alone. That's privacy, okay? So the U.S. Patriot Act started changing some of our notions to privacy, which, by the way, has gotten us into trouble with the EU, which is one of the reasons we now have GDPR. They think we're all children who can't understand privacy. But I'm not going to talk about this. When I was doing my stint with Homeland Security, which is actually what motivated me to go to law school, because I thought, erroneously that people would actually care. Want to have somebody that understood technology to understand a lot of this group detection, event detection, and the like. But basically, it created programs that enabled more spying on us in the interest of national security. I always cynically say when people say privacy, I say, you don't have any privacy, get over it. That offends some people. But here's my point. How many times today were you on video? Okay, just this past week, there was a horrible murder in Houston. A bicyclist came up on a doctor who was bicycled beside him or behind him for about half a mile, passed him, pulled a gun and killed the doctor, cardiologist, world famous cardiologist. Nobody can understand, and it's still being investigated. How did they pick up who this guy looked like? They took all the videos from everything along the way, including buses, metro buses, videos on the street, private video cameras. Did you have possible footage? Ironically, the actual murder was in a place that there was no camera. The assassin or murderer got on his bike and pedaled away. Okay, so my point is, when I say you don't have privacy, get over it. You walk down the street and you're being videotaped. You don't know how many times, videotaped. God, that shows how old I am, right? But you're being videoed. So when I say that, I don't say it cynically. I just say, I am being cynical. We are on video so much. Our data is shared. Facebook, Cambridge Analytica, all of these things. And by the way, Cambridge Analytica violated no U.S. privacy laws, in my opinion. So when we talk about privacy, one, it is the tipping point. Now our computer security, my credit cards were hacked, IP stolen, yada, yada, yada. But by golly, now I'm beginning to realize that by facial recognition and everything, that there is all this that can go and not let me alone, for lack of a better term. I want to be let alone. I want my privacy, right? So the Patriot Act gave the federal law enforcement a lot more leeway. If you read the analysis of 9/11, there's a book called, and I want to say it's called Nowhere to Hide, or maybe No Place to Hide. The 9/11 hijackers, there were 19 of them. There should have been 20. This is one time when border immigration didn't allow the 20th in. So there were 19 hijackers. When this first began to investigate, where did they come from, where they've been, trace all of this stuff, they had to go to private companies to get the data, the credit card companies. That's where they began to track their movement. right? And the response was, as law is always reactive, hey, we should have the federal law. If the private sector can do this, why is federal law enforcement having to depend on others? Okay, so that's the Patriot Act. I talk about in my law and policy class relevant to critical infrastructure because it's got a wonderful definition. I will just leave you on the edge of the seat wondering what that is, so you can sign up for my class. Graham Leach Bliley is on financial industry and privacy provisions, an opt-out method for individuals to maintain some control. It allowed you, believe it or not, at one time, you couldn't get your credit report. It's they had to pass a law for a credit reporting act. I was surprisingly just denied credit for Bucky's credit card 2 weeks ago, and I'm look at my credit history, and I'm like, and I can right away, why did you not give me this Bucky's card? This is ridiculous. I decided, forget it. I don't need a Bucky's card that badly, but it's kind of humiliating when you get the rejection letter. That hadn't happened to me in 20 years. But the Fair Credit Reporting Act gave us that right. Let's look at our financial history and let's be able to correct errors. SOX is another big one. Sarbanes-Oxley, financial accounting standards. Again, 2002. What motivated this? What motivated this was Enron. Enron wiped out 3 people I personally knew. Man in his 50s, had all his retirement, lost it. My former brother-in-law lost a lot of money in it, led to some alcohol abuse for a while. But Exxon was precipitated passing SOX, Sarbanes-Oxley, again named for 2 senators at the time who put the legislation in. Basically, it requires the C-levels to personally be liable. So for the accounting and the controls that come out. So even though many argued this was already inherent in the 1933-34 laws that established the SEC controls any publicly traded companies, they passed this because the CEO, who, by the way, had a PhD in economics, Ken Lay, said, gee, I didn't know all this malfeasance was going on under my nose. So they said, let's put in some personal accountability. So SOX applies to businesses, and it requires third-party auditors. There used to be an accounting firm called Arthur Andersen. Arthur Andersen was Enron's accounting firm. Accounting firms, law firms, and all this, if you're a partner, your whole retirement is based on the value and the equity that you have built up in that firm. So you don't ever hear of Arthur Andersen anymore because it no longer exists, because the liability from Enron destroyed all their partners' equity, even though probably 90% of them, didn't even touch Enron accounts. So we'll talk more about this in depth when we do our law and policy class. I want you just to know that there is this Sarbanes-Oxley. There is some legal arguments that because it requires knowledge and signing off at the C level, the CEO and everything at that level for financial auditing, that you could say, take that to cybersecurity. How can you have proper financial controls in place if you don't have proper cybersecurity controls in place? I have heard that legal argument. So that's SOX. Now privacy. We have HIPAA, healthcare, FERPA for your education records. When I was in college the first time, they posted your name and grades on the door. You didn't even think twice about it. I took Russian, so they put your name in Russian. Well, gee, that was hard if you'd taken the class to figure out who, you found out which people in the class lied, and they told you they got like a B and they got a C- or something, but whatever. So there were these privacy laws. Now, here's what I want to say about this. I'm going to, I think, go on and upload a video, if you're interested, that I did on GDPR for my law and policy class this summer. Again, privacy is the tipping point. If you have your fingers on the keyboard, if you are dealing with information that is processed in the EU, you now come under this GDPR. And some argue that if you're processing information on a resident or citizen of the EU country, regardless of where they're living, which is a good population of Houston in the oil and gas industry, for example, you come under this law. Because you take a transaction from them and it's a link to a charge card back in the EU country. Here's the challenges for this. General Data Protection Regulations, GDPR. One is most people don't know which countries are in and not in the EU. They're quite surprised to find out Liechtenstein, Switzerland, and Norway have never been and will never be in the EU. Britain's got one foot out the door and one foot in the door. The former Baltic republics, Estonia, Latvia, and Lithuania are now in the EU. Turkey wanted to get in the EU. And in the end, when I talk about GDPR, it doesn't matter because Mexico and Canada are looking at passing similar laws. Countries in South America have passed laws. Singapore has passed a law, and you're like, well, why is she droning on about this? Because GDPR is very draconian compared to U.S. privacy laws. It puts restrictions and requirements and constraints on U.S. businesses that are much heavier than that imposed by U.S. law. All right, so that's our law. I've talked about this. This is an industry standard. This is the way a good economy should work, I think. You get the industry, Congress could pass legislation, or you can get MasterCard, Visa, all the cards, set a set of contractual rules. This isn't statutory, this is contract. You sign your name on a contract, and you may, in fact, unless it is violates public policy or is considered very onerous, or you can prove that you lacked mental capacity when you signed it or something else, you're bound by that contract. But gee, I didn't realize that when I said it was fines up to $500,000, it meant really $500,000. Well, by the way, by comparison, GDPR fines levied by the EU is the larger of 20 million euros, which I think in today would be maybe 24, 25 million, the larger of that, or 4% of your gross national or international sales. So suddenly that 500,000 limit, that doesn't look bad. Okay, if you're a software engineer or a hardware engineer, or you develop any kind of technology, you need to know about the import-export laws. Now, he talks about encryption here, but in fact, the import-export technology laws just are on technology. Anytime, I don't care what the technology is, I have a client or I'm advising someone on any kind of international trade, I always request, advise, demand that they put in an import-export control restriction. He talks about it here just applying to encryption. It turns out the law applies to any type of technology. So, belts and suspenders, put it in your contracts. It basically says you cannot put this U.S. produced technology, even if you paid for it out of pocket, you cannot sell it to certain countries that are on our bad list or certain individuals that are on our bad list, and that bad list changes. You have to go to the links on the State Department or something. And by the way, if I sell, and I did this at one time, I sold my software to what we used to call a VAR, value-added retailer. I don't know if that term's still in vogue, in the UK, and they sold all over the world. So even so, I can't say, well, I sell to the UK and they're responsible. No, I cannot abdicate my responsibility under US law. So always put this in your contract. Encryption doesn't matter. He talks about encryption because that's what caught a lot of early people. Phil Zimmerman, who invented PGP, others. Quite frankly, if Bill Gates and Steve Jobs were starting their companies under today's laws, they'd both be in violation of existing legislation, right? So he talks about this on the encryption. If you're interested in this, good. Like I said, there's 2 books if you want to be an entrepreneur, which, by the way, I'm also teaching digital entrepreneurship this fall. I recommend every entrepreneur or even if you're not an entrepreneur, and one's an ABA book on technology contracts, one's a NOLA book, NOLO, I can't remember what it stands for, on IP. But you do want to have this in your contracts. There is this whole government infrastructure set up. Dr. Conklin thinks this is important. It is important. Again, if you get to this level of encryption, don't be doing it by yourself. Okay? Now, we talk about non-U.S. laws in this Wassenaar arrangement. Yes, it's important. This is, again, encryption. He's focusing on the electronic. Anytime you now have a technology that is going to be outside the United States, you just need to be aware of these agreements and arrangements. We've talked about a little bit about digital signatures, how they're used to identify the source, to establish the integrity and non-repudiation and the like. in the old days, you signed your name and that was it. You had a stamp, you did something. Now we have digital signatures. The big things you want to remember about this: integrity and non-repudiation, and that there are laws governing this to greater facilitate and enable our commerce. There is an interesting thing on this slide. If you say another source of law in digital signatures is the Uniform Electronic Transaction Act. You have to be careful sometimes. There are certain things that are called, that when they start with uniform and end in act, are actually model laws. So this is one. It's been adopted in states. It was developed by the National Conference of Commissioners. So what they do is they basically say Uniform Electronic Transactions Act. It's not really an act. It's not really in place. Here's what the model law should look like. And then our 50 states say, okay. And so then they take it and tweak it, okay? Or they don't adopt it, which is what happened with this. And so what happens? It goes through litigation. And then let's say, I think it's like Illinois, New York did not adopt this. Then what I'm going to argue is jurisdiction under state that did adopt it if it benefits my client, or jurisdiction in state that didn't adopt it. So you have all this, but just be aware of this. When you say uniform blank blank act, typically those are not real acts. They are model acts. Industry groups get together and say, if the world were perfect, this is the law you would enact. And then it gets passed to the state. UTSA is the Uniform Trade Secrets Act, same thing. There's a 204-page table that explains the differences in the states, not a document, a table, of how the 50 states all implemented their own version of the UTSA. Well, it's the same thing here. Okay, we've got the UN coming in. We've got NATO coming in. I was at a conference this week, and a colonel mentioned NATO Article 5 used in the Talon Manual. And again, I'm ruining all my good secrets in law and policy. But when you talk about these, yes, you have a mandate to harmonize this. But guess what? They have this model law. Do you see that? International trade law, model law. That says it's aspirational. Great. If everybody abides by it and it works, great. But that's not what happens. So what's now on the forefront in law and policy and cybersecurity is the Talon, meaning Tallinn, Estonia, the capital of Estonia. Talon Manual 2.0, Manual 2.0 on international law on cyber operations. And in big font, front of the page, title, International Law. It's the same as this. It was put out by NATO experts. It is not law. Some of it is. Some of it you could say, oh, it's case law. It's based on this case or that case. Other, it's purely aspirational. So you have to be really careful when you see things from the UN, from NATO, when something says the model law, not really law. We go to court, guess what? I'm arguing law, statutory or common law, but don't be giving me something that's the shoulda, coulda, woulda, right? I'm not going to go through Canada. We're seeing more harmonization. What you should be watching for in both Canada and Mexico is if they implement GDPR. It's going to really affect our NAFTA mechanisms and the like. Then we have the European laws. I'm not worried so much about digital signatures in the European laws. What I want you to be worried about right now is GDPR. Now, this is a biggie, Digital Rights Copyright Act. I said there were two. You could be, get your hand slapped and put in prison and have your life and career ruined. Digital DMCA, people think that this Digital Millennium Copyright Act, it did not create copyright law. It is based on our existing statutory federal copyright law. However, it created new rights under that law for electronic assets. So, if I pull something down off the internet, it's protected, right? It created new rights. It has been, again, misused. It has all these exceptions. Oh, if you use this, you don't violate it if it's for research purposes or if you need it for interoperability or da-da-da-da-da-da. And every couple of years, the Electronic Freedom Foundation puts out a misuse of the DMCA. And I've also had students come and say, well, the EFF says this and the EFF says that. And I'm like, yeah. And guess what? That may be persuasive, not legally binding. Always, 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 we look to the law, not what we think the law should be. So there's a lot of controversy with this. If you're interested in this, I'll be more than happy to provide sources. I want you just aware of the law now. I want you aware that it is based on existing copyright, the United States Copyright Act. All it did was take that and create new rights for in the electronic age. It did not change our fundamental notion or legal concept or definition of what constitutes a copyright. Now we get into a hot one, ethics. I'm already 20 minutes into this video. Ethics, what's right or wrong? What did you learn at your mother's knee, right? That's where our ethics start. What was in your family? What was in your community? I can't teach you ethics. You have a moral code. But what I can tell you is you go out in the business world, your business ethics trumps your personal ethics. So you may have personal views that you consider to be ethical, and they are in conflict with who's signing your paycheck. You have to go by the business. And this gets some people in trouble because they confuse making a moral stand or they'll claim, infringement of First Amendment rights when there is no such First Amendment right. The problem we have with ethics now, I think in cybersecurity, the biggest issue we have is the issue of hacking back. When does my being on the defense go on the offense? When do I do something I don't feel good about? Right? It may be perfectly legal. Some of the biggest atrocities in history were governed by law, but they were clearly immoral and unethical. So it's a conversation into itself. We don't have a lot of ethical standards. ACM is just now under review. Many of our ethical standards date back to the 90s, before the internet was so pervasive, before we had things like sexting, cyberbullying, false information, or fake news. And so, again, I cannot give you a good standard other than to say, we're Aggies, right? You don't lie, cheat, or steal, or some conglomeration of those words. But you also have this moral judgment of doing what is right. And so we are now in a very uncertain legal and ethical framework regarding cybersecurity. There's an old saying, whether it's Chinese or Sicilian or whoever, may you live in exciting times. These are exciting times, but we don't have guidance. We are in an uncertain legal and ethical framework. Let me leave it at that. You need to be knowledgeable of the law. You're going to have your hands on the keyboard. You're going to be seeing data that may be protected by different laws. You're going to have to make decisions. You're not going to have a lawyer sitting next to you saying, do this or do that. The best you're going to do in some circumstances, if you go ask for legal guidance, maybe get, if you get a turnaround in 2 weeks, that's probably average. 2 days would be, wow. 2 hours would be, wake up, you're dreaming. So we have these laws and rules. Computer access and trespass. We have this encryption and digital right management. We have all of this in place, but the big key takeaway is law always lags technology. Bad things happen. We don't have a law. We put a law in place. Sometimes the law overreaches. The original Computer Fraud Abuse Act, CFAA, believe it or not, was passed in reaction to a movie called War Games that came out in the early 80s. And some senators started saying, gee, this could happen. So I'm going to leave it at that. If you have any questions, I'm here for you. Thank you.